warmly welcome IIMT University Chancellor Sri Yogesh Mohanjit Gupta sir, Vice Chancellor Dr. Deepa Sharma ma'am, Pro Vice Chancellor Dr. Satish Bansal. Our honorable guest for today is Rashmi Tyagi ma'am from the Ministry of Commerce and Industry. Rashmi Tyagi ma'am is Manager at Cell for IPR Promotion and Management. He belongs to the Department of Promotion for Industries and Internal Trade. I warmly welcome our Honorable Deans, Dr. Subhash Chandra Lady sir, HOD Vishal Sharma sir, our Senior Teacher, Dr. N.K. Mishra sir, on the third day of 6 days online workshop on IPR Youth Innovation for a Better Future. IIMT University is hosting this program, that is a 6-day online program and 6 days online workshop on this program. Our today's guest, as we have Rashmi Tyagi ma'am. She is manager of CIPM and DPIIT. Rashmi is having an experience an IT professional and works as manager in CIPM. She is postgraduate in biotechnology and IPR trained by TIFAC 2008 batch and has an extensive experience in the field of intellectual property. Her expertise is in patent search and analytics, drafting and prosecution at IPO. She is registered patent and trademark agent as well. So I will request our guest, our mentor for today, Rashmi Tyagi ma'am. Ma'am, please elaborate us with your words and with your knowledge. Rashmi Tyagi ma'am. Rashmi Tyagi ma'am, can you hear me?
Yes, I can hear you, Vibhor. Am I audible?
Yes, ma'am. You're very much audible.
Thank you, Vibhor, for your very kind words. So, a very good afternoon to all the participants and the faculty members. And at the same time, I would like to wish a very happy World's Intellectual Property Day to all of you. And at the same time, I would also like to congratulate the university to for taking this initiative and to come up with this 6-day workshop wherein the participants can know about the various forms of intellectual property and why at all protecting the intellectual property is important. So that is a very good initiative being taken by the university, and I believe that the participants are gaining a lot from these sessions. And in furtherance to this, today I'll be interacting with the participants majorly on the drafting procedure, how to draft a patent application, what is the filing procedure for the same, where to file the application, what should be the content of the application, and how to draft a good patent application to make your patent enforceable. So I'll start with sharing my presentation first. So just for the confirmation, is the presentation visible to the participants?
Yes, ma'am.
Yes, ma'am.
So I believe the audience is well aware of what is a patent. So a patent, it is an exclusive right which is given to you by the government in consideration of the disclosure you provide to the invention. So to get the right, you have to disclose the invention. So why disclosure is such an important part of a patent? It is because it serves n number of purposes. Because once there is a disclosure, it comes into the, and it is into the public domain. So that is a source of information to the researchers, to the scholars, to the competitors. So it is a document wherein you can find the information related to a technology, to the products. So that is why a disclosure is very important, and it is a quid pro insecure situation also, wherein to get the right, you have to provide something. So it is the price of the grant of the exclusive right, which is granted to you by the government. So as I mentioned that why disclosure is so important. So disclosure is important because it is access, and it is a source of information for patent office, of course. It is at the same time, it is a source of information for your competitors, the licensee. Let's say you have an invention protected, and but by looking at the disclosure, someone gets interested in seeking license or the buying the technology. So for that, disclosure needs to be in public domain. It needs to be published, and by looking at the disclosure, by accessing to the information present in that, one can decide about licensing that particular technology, or about buying that particular invention, or to develop further over that technology. Again, according to a survey done by WIPO, it has been mentioned that about 60 to 70% of the information about a technology is available only a patent document, and in this information you cannot get in any other form of publication, like in the research paper or other things. So our patent disclosures, they are a huge source of informations. And the same time, they are also important to our technical peers and the skilled persons and the researchers who are involved in research, so as to have a fair idea of what all solutions are already there, available, what all problems are still existing, so that they can come up with some better solution by reading such disclosures. So disclosure is very important. Then why it is important to have a properly drafted disclosure in patents? Because to enforce an patent, the key is the our disclosure only. So no matter how groundbreaking your invention is, but if your application, your disclosure, it is not drafted properly, so the worth of the technology or the invention is insignificant. So we can also say that the strength of a patent, it depends upon the quality of drafting a patent application, what all information has been provided. So patent specification is basically, it is a techno-legal document wherein you provide all the technical information about an invention, and the legal part is the claims of the patent specification. So it is a self-contained document. That is why utmost care needs to be taken while drafting a patent application. And for India, the guidelines, the format, and the requirement of a specification has been well defined in the Patent Act. So today we'll be discussing all that. I'll be covering each and every heading of a specification. So in India, we provide disclosure in two forms. Basic, one is provisional specification and another is complete specification. Provisional specification, it is the document wherein you disclose your invention. So disclose as much as possible whatever data you have, whether you have conducted any experimental data, any clinical data, that also you can include in the provisional specification. So that whatever information you are having when you have your invention at the idea stage or the concept stage, you disclose in the provisional specification. So we can say that why to file a provisional specification at the first place? Because it provides you many benefits. First benefit a provisional specification provide you, let's say your invention, you are just on the concept stage or idea, and you have just initiated it, and you are not have not completed it in the invention, certain data, certain experiments you still need to carry out. But if you file a provisional specification today with all this information, about your invention may not be the complete information. You secure a priority date. So seeking a priority date is very important. So by this, you get the benefit of prior disclosure. So anything which comes up after filing the provisional specification won't be considered as a prior art for your invention. So what is the difference between the provisional specification and complete specification? Complete specification is also the disclosure of your invention, but it is the detailed disclosure wherein whatever information was missing or not provided in the provisional specification because of the fact that the invention was not complete, now that needs to be provided, and it should enable a person skilled in the art to carry out the invention. So all that information needs to be included in the complete specification. And the most major and the most important most specific difference between the provisional specification and complete specification is the claims. Provisional specification does not contain claims, wherein the complete specification you have to provide the claims also. So the claims are the very important part of a disclosure. They are the elements over which you seek protection. The claims only define the extent of the protection you seek. So once you file the provisional specification, you get 12 months time to file the complete specification, and that time is sufficient enough to complete your invention and provide a good disclosure. As I've already mentioned this, why at all filed a provisional specification? Because there is an urgency and you want to seek a prior date. You are not able to complete the invention. Still, you need time to complete the invention, or you are planning to have a disclosure of the same invention. Then it is always advised first file a provisional specification, then only disclose your invention. In that case, your disclosure won't become the prior art for your own inventions. And for let's say you have a fair idea that there is a competitor who is also working in the same technology and on the same invention. So it is always advised to file the provisional specification first, and then proceed with your invention and further research, because in that case it will serve as you can seek a priority over the competitor in this case. And other benefits which are associated with filing a provisional specification, as I mentioned, it provides you a 12 months time to file the complete specification. So whatever information was left out in the provisional specification, that can be provided in the complete specification. A provisional specification, there is a misconception. People often take it as that provisional specification is a rough draft. No, it is not. It is as important as the complete specification, because once you file the complete specification for a already filed provisional specification, the scope of your invention is always judged from the provisional specification. So it is not a rough draft. That is why enough details needs to be provided in the provisional specification also. And if you have any supporting drawings at the time of filing a provisional specification, that also needs to be incorporated into that. So patent drafting, what are the elements of the specification? So the exercise is known as the drafting of the patent specification, wherein you provide your disclosure in a well-defined manner, according to the guidelines and the rules as specified our patent office. So we accordingly draft the description and the claims. So description discusses the details of your invention for which you are seeking the protection, and a description should reflect the novelty, inventiveness, industrial applicability of your invention, and the patentable subject matter for which you are seeking the protection. The second part of the patent specification are the claims, which define the legal boundaries of your invention for which you are seeking protection. They are the basic operative part of the specifications because they defines the meets and the bounds of your invention, and they are only they are the only part which are assessed at the time of infringement proceedings. So the claims gets interpreted, they are being interpreted. So it is very important to draft the claims with utmost care, and they should be drafted in a good, well-defined manner. So it is section 10(4) of the our patent act, which clearly mentions that the specification shall fully and particularly describe the invention, its operation or use, and the method in which it is to be performed, as well as one should disclose the best method of performing, so that a person who is ordinarily skilled in the art is able to practice the invention by just by reading the disclosure of your invention. This I have already mentioned, that disclosure must describe the invention, and there should be enough explanation to whatever problem the invention is solving, and how a person who is already ordinarily skilled in the art can carry out the invention easily, and the best mode of the invention which you know. Then we comes to the contents of the specification, what all needs to be included in a complete specification. So it is the title, preamble, field of invention, background, object, summary, claims, drawing, abstract, deposits. So these are the major headings which needs to be elaborated in your specification, and I'll be taking each one of these in details. So title of your invention, it should be clear and precise, and it should indicate the subject matter of your invention. Let's say your invention relates to a process, or it relates to a product, or it relates to a apparatus. Then title should be clear enough to mention that subject matter of invention. So there is a requirement which has been mentioned in the act, which says a title should be 15 words only, and you need not to describe the invention in it. I have tried to explain it with the help of few examples. Let's say there was an invention which was related to a toothbrush. Then one of the possible title can be oral care implement having an adjustable mask centroid. So like this, we can draft our title. Then there is another example we can take, which is for a pen. We can say a writing instrument for forming thermochromatic handwriting. So like this, we can formulate our title. Then we should, while formulating a title, one should take enough care that not to use any form of fancy expressions, or the title should be free from ambiguity, which means it should be clear and precise, and it should give a fair indication of the art or industry to which it relates. Like here, if it was relating to a toothbrush, we have clearly mentioned it that it is an oral care implement. If it was related to a pen, we have clearly mentioned that it is a writing instrument. Then we have a preamble page. So preamble, it's basically we provide on the first page. So likewise, I mentioned earlier also, provisional specification and complete specification are the two types of specification in which we generally disclose our invention. So in the case of provisional specification, the standard preamble is the following specification describes the invention, wherein in the complete specification, preamble is the following specification particularly describes the invention and the manner in which it is to be performed, because it is the detailed description of your invention. So that is why the preamble is much more specific in case of the complete specification. The other heading which comes is, after the title, is the field of the invention. So it is, we can say it is the to give the formal introduction to the invention, we write the field of the invention. So in general practice, it should begin with a general statement about the invention, and then you can specifically mention the scope and technology of the invention. um, so obviously it is having more details than the title, and sometimes it is used as a tool for search, like whenever you are conducting a search. So whatever search strategy, whatever you are searching, sometimes that particular things get covered in the field of invention. So field of invention is very important. And in practice, we generally follow the language this invention relates to. Herein we can say this invention relates to oral care implement, for example, and then we can mention, we can start from shortly the oral care implement, and then we can limit it, make it more specific, and says more particularly to a toothbrush with a adjustable head. Like this, we write our field of invention. Then comes to the background of the invention. So this is very much similar to the literature survey. Herein we mention all of the state of the art relating to the subject area of the invention. Herein we contain all the previous prior art available in the public domain. And in this section, we also focus on the prior art, like what are the disadvantages of the already existing solution, and how our solution is different from the existing solution, and what all of the disadvantages were there for which we are offering a better solution. So this should be clearly distinguished, the advantages and disadvantages of the prior art. We can distinguish in this particular element of our disclosure. So herein, when it comes to mentioning what all consider as prior art, that prior art can be any patent or any application, or if that subject matter or that research is disclosed in a technical literature, or any similar technology or any similar solution that is available in a technical literature, that can be the part of the background. Then any information from the books, journals, website, anything, the information which is in the public domain related to the subject matter of the invention can form the part of the background of the invention. Then objects of the invention. So objects is basically provide the advantages of the claimed invention. So we need to define each and every advantage here. And it should bring out the positives of the invention, the essential aspects, as well as any preferred or optional aspects. Let's say while formulating our specification, or while conducting the research, we have come up with a solution, um, let's say to solve a problem. But while providing our object of invention, we should have a clear image that just not for this particular solution, or we should mention it, but we can extend the scope by saying that yes, this is the solution I am providing for the existing problem, but in future this can also be solved by the particular invention, though you are not solving that particular thing right now, but that also you include at the time of the disclosure in the object of the invention, so as to secure a broader protection. So you have to be that futuristic, and you have to formulate your objects in such a manner. The standard language which we basically use is the principal object of the invention, is wherein you mention the basic most prime advantage, then the other advantages with like another object of the invention is a further object of the invention is. Likewise, we cover all advantages in the object session. So summary, as the name itself makes it clear, so it is the summarization of the invention, wherein you explain the most essential and distinguishing features of the inventions, and the novelty and the inventive step of your invention. And in practice, we can also say that broadly it is paraphrasing of the independent claims of your disclosure. So the language we basically use is the embodiments, wherein you say one embodiment of the invention is, one further embodiment of the invention is. So it is here you cover the essential features one by one. Detailed description of the invention, wherein you will be explaining each and every aspect of your invention, your working, the components, the various configuration. So everything you will be describing in the detailed description, and it should be but the description should be elaborative enough. And in the description part, you can also include the examples, the illustrations, the tables, graphs, and diagrams, whatsoever makes your description sufficient enough so that it enables a skilled person to carry out that invention, that needs to be included in the detailed description. So there are few things you should keep in mind while you are writing your detailed description. The terminology you use should be consistent. Let's say if you are using the short form of something, then it should be consistent. The words you are using, the synonyms you are using, that should be consistent throughout the document, and it should be well organized. It should be in such a manner, if you are describing, let's say you are describing a process, then it should be described in such a manner that this is the first step and this is the second step. So it should relate. It should be well organized. Then you can start with the general overview, and you can then provide the details. So that can be one approach. You can formulate the disclosure, or you can provide the disclosure and the detailed description. So it depends on your invention, and yes, you have to provide all the information in a well organized manner. Now we come up to the most important part of our specification, which is claims. So they are the most important and valuable part of a patent application. They have the greatest significance, and every application must include at least one claim. So, and the scope of your exclusive right, as I mentioned earlier, it's always determined by the claims. So how to draft the claims? What are the elements of the claim? What are the components of the claim? So claim, which they should always start in the different page. Once you have provided all the information, preamble, title, background, summary, and the detailed description, then you provide the claims. So the preamble we use is I claim, we claim. If the individual, the inventor or the person who is seeking the protection is the individual, then we write I claim. But if it is a legal entity or a group of individuals, then we write we claim. So structure of the claim. So we can say the structure of the claim, it's basically we divide it into three parts, wherein there is an introductory phrase, the transition phrase, and the body. So introductory, as the name suggests, wherein you introduce the subject matter of the invention. Let's say your invention related to it was related to a toothbrush. Then a toothbrush, you write it is the introductory phrase. Then we have the transition phrase and the body. Transition phrase, it joins your introductory phrase with the body of the claim, as the name suggests. The most commonly used transition phrases in the practices are comprising or consisting. So I'll elaborate on the transition phrase later. And the body, so rest of your invention, that forms the body of your invention. So I have taken an example. Let's say a toothbrush comprising a handle, a head attached to the end handle, the head having a front, and so on. So herein a toothbrush is the introductory phrase, transition comprising phrase, and rest is the body of your claim. So transition phrases, as I said, most commonly, most generally used are comprising or consisting of. So comprising of, they are the open-ended phrase, which means they do not exclude any additional recited, unrecited elements. Wherein, for example, we mentioned a toothbrush comprising a handle, which means a toothbrush it will be comprising a handle, but it will be comprising other things also apart from the handle. So while we using a comprising as a transition phrase, it implies that we are not excluding any additional unrecited elements. So the scope of protection here is broader. Then we have a closed phrase, which is consisting of is much more limiting than the comprising phrase, and it limits the scope of the claim to nothing more than specifically recited, which means if we use the consisting, then any other unrecited element that gets excluded. So typically we use this consisting in case of the invention which are related to our chemical composition of pharmaceutical domain, because there is the composition is very specific. So there is a point of valid point that we use consisting of in spite of comprising. So as I've already mentioned that claims defines the extent of protection. While drafting the claims, you should take care that if the claims are concise, precise, and they accurately expressed in legal terms. And you first begin with the broad claim, and then you move toward the claims which are narrower or limiting the scope. And any subjective word like thin, strong, major part, or any adjectives when required, any all sort of words which are subjective in nature should be avoided while drafting a claim. So as I mentioned that every document should contain at least one claims, but there can be n number of claims in a patent document. So the first claim of your patent document is always an independent claim. There can be more than one independent claim in a patent document, but the first claim is always the independent claim. So why do we call it as independent claim? What is the importance? What is the significance? Because it defines the essential novel feature and the most preferred embodiments, the inventive step of your invention. And when we say independent, that implies that it is a standalone claim. It does not depend on any other claim, and it is usually the broad claim. For example, if the invention relates to an pencil which is having an eraser, then the first claim, which has to be the independent claim, can be a pencil having an eraser fastened to one end. So which makes it broad enough. Then the other claims of the patent documents are dependent. Dependent means either they are dependent on the independent claims or other dependent claims of the documents, and they are narrowing the scope of your claims. So there can be multiple independent claims in a document. Likewise, there can be as there can be many independent claims in a document. So for the similar same example, which was related to pencil. So first claim I mentioned that it is the independent claim, wherein we say a pencil having an eraser fastened to one end. So broader scope, independent claim, standalone claim. So the dependent claim of this first claim would be the pencil as claimed in claim 1. Let's say it was the claim 1, wherein said eraser is fastened to the pencil on one end using an adhesive. So here we have limited the scope, wherein we specifically mentioned, yes, there was a eraser which was fastened to the one end, but it is fastened using an adhesive. So it is limiting the scope. So there are few examples I have taken. Let's say there is a invention relating to a chair which is having a seat and a backrest, and it is a 5-leg chair. Then the most possible for first claim can be a chair comprising. Here a chair is your introductory phrase, comprising is the transition phrase. A seat, a backrest, and at least one leg, it is the body of your claim. So this can be one way of drafting the independent claim. Then I have taken an example of a fan which is having a hub and it is a 3-winged fan. Then the possible independent claim can be a fan comprising a hub configured to rotate and at least one wing attached to said hub. So likewise, we can draft the claims, and again, as you can see, if you see the structure and the language of a claim, you can easily say that they are techno-legal in nature. Then there are types of claims. We also categorize claim on based on the subject matter. So if there can be process claim, product claim. So if your invention is related to a process, then definitely the claims would be process claim. Then product claims. Product claims can be in the case of the invention is related to an apparatus, a system or device, or any other article. So, and patent specification can have a combination also, like it can have process claim also and product claim also. Similarly, it can have system claim also, and method claim also. So that combination also we can put in our patent specification. So product claim, I have given an example. It is related to a cooker, wherein we can say an apparatus for cooking rice comprising. So herein we define what all elements are there: a means for holding the rice and a heater configured to heat the rice, holding means. So likewise, we can draft our claims. Once the claim are drafted, then the another important element of a complete specification are the drawings, which makes the invention easy to understand, and how the configuration or the invention works can always be depicted by the way of providing drawings. So how to draft the drawings, what are the essential things that keep in mind while preparing the drawings or while providing such drawings. Such drawings should be always provided on separate sheets, and they should be the scale should be sufficiently large enough to clearly show the invention, and dimension need not to be marked. They should be sequentially numbered, and there should not be any descriptive matter or any labeling should not be there. They should only be numbered. Abstract, so abstract, it is much more similar to the abstract we provide in our technical journals, research papers. So again, it is the concise summary of the invention, wherein you clearly define the technical field, what the problem the particular invention is solving, and as per the requirement of the act, it should not exceed 150 words. You have to describe, you have to provide an information in the abstract in 150 words only. And according to another requirement of our patent act, you have to include the reference numerals. So these are the reference numerals. Let's say your abstract, it was related to a apparatus or it was related to a method, so wherein you are mentioning about the various elements of your particular apparatus, you need to put in the reference numerals, the numbers you have explained in the drawings. So that numbers you have to put in your abstract wherever you are explaining any particular element or any particular configuration or any particular part of the invention or the apparatus of your invention. And then you have to provide the figure number also. Let's say you provided 10 figures, but one figure is the overall figure or is the major figure which depicts your entire invention. So you indicate that number, let's say that figure 1 or figure 2. This particular figure, it will be published with your abstract in the journal when your application for the invention get published. So you have to provide that figure number. So deposit, this is basically in the case of biological materials also. So if your invention, it is related to any biological material which cannot be adequately described in the written description, then you have to deposit it to the International Depository Authority, which has been notified by our patent office. So you have to deposit that material, and you have to get incorporate the deposit details in the specification. So likewise, we draft a effective patent application to seek protection. So whenever we are drafting a patent specification, certain points which should always be kept in mind, that we should not use any jargons or slangs in the patent specification, any commonly used terms, and the terms which we are using, we should sufficiently describe them. And if there is a term which is in foreign language, then we need to provide the English equivalent of that. So we can clearly conclude that patent drafting, it is a very skill based exercise, and for this you need the techno legal expertise. And why it is important that your specification is well drafted, because it is a one time chance. Because if you fail to disclose, or you add to forget any important detail in your invention at the disclosure time, then there is no second chance you get to disclose that particular thing, or to seek protection what you have not disclosed for. And similarly, we can say that it is a one-way road, because once whatever you have provided in the disclosure and you have sought protection over that, then the scope of that particular claims cannot be broadened. So it is very important that you draft a patent application with utmost care. You seek the help of the experts, and you file a very well document to the patent office, so that it is granted, the protection is granted easily over that. So it is important to remember that you do not get a second chance here. So draft a very good application. While drafting a patent application, certain things you should keep in mind before drafting it. Understand the invention completely, identify the construction, the crux of the invention, consider all possible embodiments. Like I already mentioned that maybe you will not incorporating that embodiment in your invention this particular time, but in future you may come up with that particular embodiment or that particular optional feature. So you include that also. Plan the structure, like how to formulate the entire invention into different headings. So this all you need to take care of. And yes, always involve the inventor while you are drafting the application, so that they can provide their valuable inputs at the time of drafting and nothing is left out. So yes, claim drafting is all about precision, clarity, imagination, and foresight, and utmost care needs to be taken, because a well drafted document is the key to the commercialization, is the key to enforce your right. So I think we can end the drafting session here, and then I'll be moving on to the filing procedure. But I would like if any questions are there for the moment.
Yes, ma'am, some questions are there. I will request all the participants, they can ask their question all by themselves, or I have some questions in chat box as well.
So there are questions in the chat box.
Yes. Meanwhile, ma'am, Kalpana Sangar is asking that what are the benefits government provide related to patent to the startup in biotech field?
Perspective, the startup is in which field? The government has come up with many initiatives to promote the filing by the startup. So the foremost benefit which is provided to the startups is the rebate in the filing fees, wherein they get 80% discount. For example, the filing fees for the startups, individuals, and other educational institute is rupees 1000, whereas for other legal entities it is 4000. So that is the huge rebate, and you get it throughout the other things also, like any office action, renewal fees. So everything has been rebated. Then the government has has also provided the option of expedited examination and expedited the early publication to these startups, wherein they can expedite the entire procedure from filing till the grant. So that is one more benefit which has been provided to the startups.
Ma'am, is there any possibility that the participant can also pay their fees or registration fees in installments or something? Do we provide some such kind of option as well?
Sorry, I could not hear the question properly.
Do the applicant are provided to pay their registration fee in installments as well? Is there any criteria?
No. So as I mentioned, the filing fees is rupees 1,000. So until unless you pay the fees, the application will not be considered as filed. So that you have to file one time only and the entire amount completely. So there is no option for installment as of now.
Devesh Mishra is asking that how an individual can file a patent in India and abroad.
So yes, that I'll be covering in my second part. So obviously I'll be telling you what is the procedure, how to file, where to file, what all the requirements needs to be fulfilled. So I'll be talking on that in the second part.
One more question is there. Skillmate Dhar is asking how IPR is different from plagiarism and how do we deal with that?
How, what is different from plagiarism?
How IPR is different from plagiarism? I am not
plagiarism. Yeah. So I actually have not understood the question, but I have understood the person he is trying to ask that what is plagiarism. So plagiarism is like basically it is in the field of copyrights, wherein you portrays the work of some other person as yours. Like it is a very common practice, like you copy the articles and you use it. So that is basically plagiarism. It is the right of somebody else who is having exclusive right over it, and without having his permission, you have used it and you have portrayed it as that it is yours. So that is the practice which is known as plagiarism. So that needs to be avoided. If you are using anything for, let's say, for your research purpose or anything, you need to give the due credit. So by mentioning it in the reference section, where from where you have taken that particular excerpt or that particular information, you need to give the due credit to that person. That way you can avoid plagiarism.
Dr. Vipin K. Varghese is raising his hand. Dr. Vipin, if you're there, you can ask your question. Ma'am is up for questions. Dr. Vipin Varghese. He has raised his hand. Vipin sir, you can ask your question in case you have anything. Okay, one more question is there, ma'am. Process of copyright. If I have done any advocate or any person to help, is this possible? I mean, can one register all by himself for copyright or patent?
Yes. For copyright, you can file your application yourself. There is no need to involve the legal attorney or the agent. Similarly, for the patent also, you can file your application yourself. There is no need to involve the patent agent. So those options, yes, those are available, and individual himself can file their application, whether it's copyright application or whether it is an application for a patent.
Okay, ma'am, we are good to go on the another session. Yes, your second chapter you are about to know.
Okay, so I'll share the screen again. I'll share the presentation.
Sure, ma'am, please. You're the host, you can.
So just for the confirmation, is the presentation visible to the audience? Is the presentation visible, sir?
Yes, ma'am. Yes, ma'am.
Thank you. So as the participants has already asked that what is the procedure and how one can file an application for the patent, from where to seek the protection, what all needs to be filed, what are the requirements, forms, fees, and other formality requirements. So I'll be covering all of that in this particular session. So as I've already covered the drafting, so once we have drafted our complete specification, then we have to file it to seek the right. So these are the basic documents for filing an application. So the competent authority in India is the Office of the CGPDTM, which is Controller General of Patents, Designs and Trademarks, Ministry of Commerce and Industry. So we have to file the application there. The application form is known as the Form 1, wherein you have to provide all the applicant details, the name, the address of the applicant, the details of the inventor, who all are the inventors involved in this invention. That details need to be provided with their address and nationality. Then the provisional or the complete specification, whatever you are filing, that needs to be enclosed, and the fees needs to be enclosed. So as I have mentioned, for the startups, individual SMEs and educational institutes, there is a rebate in filing, which is wherein you file for you filing fees is rupees 1,000 when compared to other categories or the legal entity. So along with Form 1, you have to fill in the Form 2. Form 2 is again your provisional or complete specification. Form 3, it is also an important form, which is statement and undertaking, wherein you have to declare that if at all you are filing any similar application in a foreign country, then you'll keep the patent office informed about the updates in that particular application, which is being processed in any foreign country. Form 5, it is the declaration wherein you mention all of the name of all of the inventors, and the form is endorsed by the inventors. So these are the very basic forms, and every application should be accompanied with. Then we have a Form 18. Form 18 is the request for examination form, because once you have filed the application, it is taken up by the patent office for examination. So that examination is not automatic. You have to request for that examination, and for that Form 18 has been prescribed, and there is a fees associated with it. You need to file that fees. Then there is another form, which is Form 28. Form 28 is to claim the educational institute, the benefits for the educational institute you are claiming. If you are claiming the benefits in the fees, then you have to provide a supporting document. You have to fill in the Form 28, wherein you mention that we are an educational institute, and you provide the recognition certificate of your educational institute so as to claim the benefits in the fees. As I've already mentioned, that patent fees for startups, individuals, MSMEs, and educational institutes is rupees 1,600 if you file it in the online mode. But if you file it physically, it is 1,750. So again, there is a 10% rebate if you file it in online mode, which again saves your effort and documentation cost. So that mode is preferred mode. Then the examination fees, which I mentioned for the natural person, individual, startup, MSMEs, educational institute, is 4,000 rupees when you file it in online mode. If you file it in physical mode, then it is 4,400 rupees. And the professional charges. So professional charges is optional. As you have already asked, and I've clarified that if you involve any patent agent or any attorney for filing your application, or you are seeking the help of any professional, then you have to pay him. Otherwise, these charges are not there. You just have to pay the fees to the government. Renewal fees. Then where to file the application? So you have drafted the application, you have drafted all the forms, where to file? So filing, the patent office in all metro cities, we have Delhi, Calcutta, Chennai, and Mumbai. And based upon your region, let's say for north, east, west, and south, accordingly your application will be filed. For north region, it is Delhi. For west, it is Mumbai, south, Chennai, and east, it is Calcutta. So you have how this jurisdiction is identified in the case of an applicant. It is identified based on the address you provide, as the address of the principal place of business, or as your address for services. So whatever address you provide in your application. Based on that, an application is accordingly filed in that particular jurisdictional office. Once you have filed the application with all the documents, you have paid the fees, then what is the procedure ahead? So we have filed the form 1 and other relevant forms, and we have filed the provisional specification. Once you file the provisional specification, as I mentioned earlier, you secure a priority date. You'll get a filing date, you get a filing receipt. Then within 12 months of filing a provisional specification of this file, the first filing date, you have to file a complete specification. So how provisional is different from complete, that I have already covered. Claim are the most important part of the complete specification, and it is the complete draft which you need to file within 12 months. This should be kept in mind that this 12 month period is not extendable at all. So if you miss filing a complete specification in this particular period, you'll not get any opportunity to file this. There is no extension available. So kindly stick to the timeline. Once you have filed the complete specification, your application will be published within the expiry of the 18 months from the filing date. So publication is automatic. You do not have to make any request. Once the 18 months period is expired, the patent application is published by the patent office. So what a publication covers, it will be the disclosure, whatever you have provided, the provisional specification. So that, and along with other forms, whatever you have submitted, everything gets published in the official journal and at the website of the Indian Patent Office. And now anybody can have access to this available information. After publication, the second stage is examination. So as I mentioned, examination is not automatic like publication. You have to make a request for examination. This request for examination you can make at the time of filing the complete specification itself, or within the 48 months of filing the application, you have to make a request. There is a fees for it, which is 4,400 in case of individual startups and MSME educational institutes. So you have to request for the examination. Once examination has been initiated by the patent office, an examination report will be issued to you, wherein the examination is basically conducted to assess the criteria of patentability and other formality requirements, like whether you have filed all the necessary forms and you have paid all the fees, and you have provided the disclosure in the well-defined guideline as it is defined as per the guidelines that is defined in the guidelines and rules. Everything is in place. So along with that, it is examined for the patentability criteria, which is novelty, inventive step, and the industrial applicability. So for the novelty section, there may be, as a part of objection, there may be raised certain prior art may be cited by the examiner. And for the inventive step also, the examiner would cite certain prior art, and with all this objection, and FAR is issued to the applicant. So once the applicant gets the first examination report, then they have to file a response to the objections. Whatever objections has been raised in the first examination report, that needs to be complied. You need to file a response to that within 6 months only. So this time is further extendable by 3 months, but to seek that further extension, you have to pay the fees. So it is advised that you reply as early as possible, so that the procedure is fastened and the patent is granted as early as possible. So once you file your response, if you have countered all the objections, you have provided enough justification and enough clarification to all the objection raised in the first examination report, then the application is found in the order for grant, and there is an intimation of the order and within 7 days of the intimation of such an order, a certificate of grant is issued to the applicant. But let's say if the controller or the examiner was not satisfied whatever response you have provided, and still more clarification is needed on that, then you will be provided a opportunity to be heard. A hearing will be scheduled with the respective examiner, wherein you have to present your case and you have to provide whatever details are required by the controller. Once you comply with all the objections and all the objections are waived off, then again an intimation for the grant is, the order for the grant is intimated, and within the 7 days of the intimation, certificate of patent is granted to the applicant. So this is the basic procedure once you file the application with the patent office till the grant. So herein, as I have already mentioned, that to facilitate the startups and to expedite this particular procedure from filing to grant, so there have been certain facility and which has been provided by our patent office. So that is the early publication and the expedited examination, wherein you can expedite this particular process. Expedited examination, you can request for the expedited examination. Similar to the request for examination, you have to file a request for expedited examination, wherein the fees is different. There the fees is 8,000 rupees, so you have to pay that fees if you want your examination to be expedited. And the for expedited examination, you have to opt for early publication also, because if you want your application process to be fastened up and it to be to fasten up the entire process, then you opt for early publication also. So unlike the publication which is done at expiry of 18 months, which is automatic, for early publication you have to make a request on particular form and you have to pay a fees. That fees is 2,500. So the general publication, which is after the expiry of the 18 months, it is automatic. You have not to make any request and there is no fees involved. But if you want the early publication, then you have to make the request, which is again subject to the payment of the fees. So this is the basic filing procedure, and all the filings can be done in the online mode. You can also file it physically, but it is suggested to save the time and effort. You file on the online portal which has been provided by the government to proceed with your all the filing procedures. So every office action or every intimation also that is dealt online. Even the hearings also, they can also be attended online. So that way the government has provided multiple benefits to the users, so that the process is smooth for the filing and the grant procedure is smooth for the applicants. So I guess the filing process is clear. So if the audience is having any questions, I would like to take the questions.
Please, if anybody has their question, they can put your raise your hand and ask the question. I think Anshul Jain has question. He is asking if I need to patent any idea or any concept, is this possible? Anshul Jain has question this.
Idea and concepts are not the subject matter of patent. Any idea or concept, you have to reduce it to practice, right? Then only you can protect it. As such, you have idea and concept, then that is a subject matter of copyright. But to have a to seek the patent protection on it, then idea must be reduced to practice.
He also have another question, same again from Anshul Jain, that the patent file is very crucial, as you said. So
Patent file is patent file is very crucial, as you say. So any organization or company to help academician or person. Yes. So for academic institutes, obviously, I guess the institute will be having certain IPR policy. So wherein they'll be having collaboration with the experts and all. So that is one way, and there are other schemes and from the initiatives from the government also, wherein they can collaborate with the Atal innovation missions, and there are other n number of schemes. So I'll provide the details to you, sir.
Yes, ma'am. Anybody have any question? They can please ask. If any participant have any question, you can please go ahead. If any participant have any question,
Can you tell about the importance and ma'am, can you tell about importance and scope of patent agent?
Patent agent. Yes. So patent agent again, they are recognized by the government. So they facilitate in all the filing and the prosecution purpose. And that is also one of the career aspect that one can be a patent agent. For that, you have to qualify the examination and you get registered as a patent agent. Then you can assist the applicants in filing process, the office actions and the prosecution process, and that can be a source of income. So yes, that is a benefit, and you can get registered also as a facilitator to facilitate startups and to help them in their filing process. And when you get registered as a facilitator to facilitating the startups, that in that case the reimbursement for whatever services you provide to the applicant, that is reimbursed by the office of the CGPDTM. So that is also one other option.
ma'am, can you elaborate or how many more careers can be in the same line like you yourself is an agent? So how many, what are the exam and exactly criteria for this exam, to crack this exam? And you can elaborate this a bit more.
Yes, so that you need to be a graduate in science, and the examination is conducted on a yearly basis. For this year, I guess the notification was already out for the examination, and it is going to take place in the next couple of months. So in that particular examination, there are two papers. One is of objective nature and one is of subjective nature. So for that, you need to have the a fair idea about our Patent Act. What are the sections and what are the rules? So the patent legislation, you need to have a fair idea about that. You need to read that. You need to have a clear understanding on that. So based on that only, there are two papers. One will be of the objective in nature. One will be the subjective, which will be more problem based thing. Like there will be question like wherein you will be given a certain scenario, and you'll be asked like what is the best thing you'll suggest in this case. So questions of this sort would be there. And after the examination process, the exam for the qualifying candidates, there is an interview. So once you qualify in the written examination and interview, then you clear the exam, then you have to get registered also on the patent agent register with the office of CGPDTM. and you have to pay a certain fees for that registration, and likewise you get registered, and thereafter you can practice as a patent agent. So that is a very prospering career perspective also you can opt for.
And can somebody practice as an agent only in his area only? As if I belong to Delhi, then I can practice only in Delhi, or
No,
can...
no. So throughout India, you can act as an patent agent. So there is no jurisdictional restriction for that. You can act as an agent throughout India.
Okay. And do the department issue some such kind of list of all the agents so that one can, if I
Yes.
am willing to
Likewise, I said that once you qualify the examination, you have to get registered. So the register of patent agents is specifically maintained by the Office of CGPDTM, which is maintained in the electronic form, wherein all the details of the registered agent is there, like his registration number, his name, his educational details, until when his registration is valid. So that sort of information is available on their online portal. Anybody can access that information and can fetch the details. So yes, that is done.
Is there any star system or ranking system that say you yourself have got 5 stars or some high ranking or something, client satisfaction based something, or we can just randomly select anybody? Is there, I mean, some criteria of getting the stars or rank or something, ma'am?
The patent agents, no, so there is no star or there is some ranking system. It is all of your thing, like how you practice and how well you maintain like this relationship with your client. So it's basically your perspective. So there is nothing like accreditation or star ranking. There is no involvement of the Office of CGPDTM or any competent authority in this side.
It's all about goodwill and mouth publicity in this area.
Yes. So it's all about how you practice, and like it's like any other career. Like if you do well, you prosper well.
Okay, any participant have any question? Because the meeting was, the subjects is covered already, and that was really very useful session for this particular patent subject. So if any participant or anybody has any question regarding the same subject, you can ask, or else we will came to an end. I think that's all, ma'am. Thank you, ma'am. Thank you very much for this session, because that was wonderful and very useful. And that is the third day of our session. And feedback form will be there. Please do fill that. And thank you very much, Rashmi, ma'am. Thank you for giving us and our participants time. And thank you all participants for this time. I again thank you. Thanks our Dean sir, Dr. Subhashan Taledi sir, our HOD sir, Vishal Sharma sir, and Prithvi Sankar ma'am, Dr. Prithvi Sankar ma'am, who is in backend support and who's the initiative, who took this initiative for this 6-day program, and our team member Nishant sir, Nishant Sagar sir, Sajjan Goswami sir, our senior faculty Dr. Narendra Kumar Mishra sir, and Dr. Vivek Singh sir. Thank you, ma'am. Thank you all the participants. Thanks for this session. Thank you.
Thank you, Vibhor. Thank you. And I believe the participants have gained something from this session, and they're going to utilize it in the future. And in case the audience is having any query related to patent, filing procedure, copyrights, IP in general, so you're free, just feel free to write to us. We will be very happy to assist you to provide answer to your queries. And again, Vibhor, this is indeed a very good session and a very good initiative taken by IIMT. And I believe that we do such much more session in the future, and we collaborate for many more events. And again, I would like to thank to the very patient and the enthusiastic audience. And of course, yes, the session was a great session and a great audience. I thank you all. Thank you, Vibhor. Thank you, the coordinating committee.